Hello again, everyone. It's Rob Ryder on Monday, February 3rd, 2014. February 3rd. And this is a redo of a video I did before, and I had to take it down. Motion Day. What's up with that? The reason I took it down is I had showed the back of a summons that I thought went with the front of the summons I was showing, but actually went with a different summons. And it had a party listed on as a defendant corporation, which in the summons of interest there was really nobody listed. In fact, there was nobody listed, and that's the point, really. Not only wasn't there a corporation defendant, there was no defendant listed that showed that they had been served. And one of the many things that you will find out when you look at paper close, that they just because something says it is what it is doesn't mean it is what it is, or that they've done what they're supposed to make it what it is, such as properly serve a summons. And so how do you take advantage of stuff like that? Well, that's what this thing about Motion Day is about, because to do a motion, there's a particular thing you have to do, and part of that is you need to get on a calendar to be heard on Motion Day. What's Motion Day? Well, it's a day they hear motions. You may be sitting in a courtroom waiting for people to show up, and they're back in another room doing the motions where you should be, but because of the smoke and mirrors and the confusion, they got you sitting here. But it's happened to Rose. Said you can look at the calendar. They tell you to be there at 8:30. You show up and you go to the courtroom that you think you're supposed to be at, and nobody shows up till 9:15. What, they got there late? No, they've been there since 8:30, back doing motions, which is where you should have been. You're not in the court, right? You're in an administrative hearing. You want to be in the court. So, more on that. And we're going to be talking about defendants and its address, because you're probably not getting the mail as the defendant. Part of this is what we're going to talk about, because you haven't appeared. Right? You got to file an appearance. If there's no attorney of record listed for the defendant, right, then they're going to send whatever notices they have and so forth to the defendant. But the defendant isn't you. It's a fictitious entity that's been made up, and they've given it an address, and the mail isn't going to come to you. Well, a little more of that here pretty soon. So, when we get this figured out, hopefully we have the uses and procedures for motions, so we can stop dancing to the piper and say, okay, this is what it looks like we should be doing. The evidence of what they're doing incorrect isn't hard to see. I'm going to show you that in the next 3 or 4 videos. I got 3 or 4 short videos I'll do just based on court cases. Boom, 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 boom. You can look through it and, yeah, that isn't there, that isn't there, that isn't there. Check me, see if I'm correct. I am correct. The question is, what do you do with it? Part of this is because, as far as the defendant, they got a thing called the name and arms clause. And that was the popular name in English law for a clause sometimes inserted in a will or settlement by which property is given to a person for the purpose of imposing on him the condition that he shall assume the surname and arms of the testator or settler, with a direction that if he neglects to assume and discontinues the use of them, the estate shall devolve on the next person in remainder, and a provision that preserving contingent remainders. So, in other words, if we have this estate, which we do have, and we haven't accepted, and this clause is in there as part of the estate from the settler, for you to have access to your estate, you need to assume the name of the surname of the settler, and the arms, right? The right to bear arms is not a gun with a bullet. It's like a distinction of some kind, like a title. For instance, an attorney has bought arms, right? He's an esquire. He paid to have the arms of an esquire. That's why in court he's called a counselor. And you're in court, they call you a mister. Well, a mister goes with gentleman, and esquire is above a gentleman. So you're not in the same class. And he paid for his, like the Ahab the Arab over there in England, who owned Harrods. Right? He had a royal charter. Well, how did somebody, an Arabian, get a charter, a coat of arms for the realms of England? They bought it. Back in the 1300s, when they had all these frickin' plagues and shit going around, they had a lot of arms for sale. They sold them. The Jews bought them. They had all the money. They were the goldsmiths. Right? They were the ones doing the all the usury and stuff, and they got all the kings and so forth in trouble. In fact, they had it so bad that they had to write a constitution for the Jews with the king. It was called the Magna Carta, Constitution of the Jewry. Carrying on. So what's a legal name? Under common law, consists of one Christian name and one surname. And the insertion, omission, mistake, or middle name or initial is immaterial. So it's a surname or a Christian name and a surname. The legal name of an individual consists of a given or baptismal name, usually assumed at birth, and a surname deriving from a common name of the parents. So, because it's a male-dominated society back in the day, they take it from the father. Now, what does all this mean? Well, your full name is, in my case, Robert Allen Rytlewski. Now, they say I don't need to use the Allen. I could use an initial, don't need to use it. My given name, Christian name, is Robert, and my surname is Rytlewski. Okay, well, how come it is, if you go look at a docket sheet, you go into court, it's going to be Rytlewski, Robert Allen. Well, it's just easier to do that way. It's for filing purposes. Well, I don't know. That particular format, surname coupled with your given or baptismal name, is considered your true real name. Not necessarily your true name, your true real name. Surname coupled with your given name. It isn't necessarily your full name. It's your true real name. Well, who gave that to you? I don't know, but that's what the court says your name is. And you walk in there myself as Robert Allen Rytlewski, they say, well, he's using a fictitious name. Boom. He's already guilty of a misdemeanor. All right, you go into court and say, well, your records say I'm Rytlewski, Robert Allen, but my given name is Robert Allen. Why don't we use that? Now, in these appearances, right, this is out of the Michigan court rules for civil procedure appearances. Appearance by party. A party may appear in an action by filing a notice to that effect or by physically appearing before the court for that purpose. Maybe go on a motion day. That's what I put on there. Now, the question is, who do you file a notice with? Well, I believe all these things that we're doing incorrectly is we go to that court window that says circuit court, district court, whatever, and we do it there. But you're actually supposed to be filing paperwork in with the clerk of the court. Not at the court window, with the clerk of the court. And probably by mail. The reason I think it could be by mail is then you could be paying the documentary tax because there's postage stamp on the frickin' mail. And you're paying for the weight of the paper, and that's what the whole thing about the stamp tax was in the first place. Right? It's free delivery. It's just what does it cost for the paper? It's what you're paying for. The weight of the paper. There's an excise tax on paper. Paper, plastic, cellophane, newspaper. They had all sorts of things at one time it was on. And legal documents had a tax. They had a stamp tax, and normally they would use a revenue stamp. And so this is part of when you do a transfer of real estate. It's supposed to have a revenue stamp on it, documentary stamp, right? So I don't know. Is that what they're saying? If you mail it in, that's better. In any event, in the latter event, so let's say you go to motion day and you say, hey, I'm here because the court. Before the court, right? Physically appearing before the court. Where's the court? First of all, when you go to an administrative hearing, that isn't the court. The court's wherever the judicial hearings are, wherever the motions are being heard, wherever the clerk of the court is sitting as part of the court. In the latter event, the party must promptly file a written appearance and serve it on all persons entitled to service. The party's address and telephone number must be included in the appearance. I wonder why that is. Why is the party's address and telephone number need to be in the appearance? Well, filing an appearance without taking any other action towards prosecution or defense of the action neither confers nor enlarges the jurisdiction of the court over the party. You haven't agreed that they have any jurisdiction over you. You just filed an appearance. But an appearance entitles a party to receive copies of all pleadings and papers as provided by MCR 2.107A. In all other respects, the party is treated as if the appearance had not been filed. Only one reason to go put it in, so you get the frickin' paperwork that you're not going to get because they have a different address for the defendant than they have for you. And I'll show you an example of that here shortly. Okay, so that's all great. Well, what if things have already happened? Well, you could get a new trial, right? But you need to do that. This all talks about what you could do it for within 21 days. But you could also get it if a defendant not personally notified, a defendant over whom personal jurisdiction was necessary and acquired, right? Like you showed up, they can bring, one way they can get jurisdiction over you is you to show up at court, right? So let's say that happened. Well, now they have jurisdiction. But who did not, in fact, have knowledge of the pendency of the action may enter an appearance within 1 year after final judgment. And if the defendant shows reason to justifying relief from the judgment and innocent third parties will not be prejudiced, the court may relieve the defendant from the judgment, order, or proceedings for which the person's personal jurisdiction was necessary on payment of cost or in conditions the court deems just. Okay, well, first of all, there is never a final judgment. All the other party ever gets on you is a summary judgment. And a summary judgment isn't a final judgment. A final judgment is a declaratory judgment. So they have a summary judgment. They're not done. So it isn't past the 1 year. It hasn't happened yet. Okay, so what may we use for this? Well, if we look in the civil procedures, this is for the civil procedures and summons. On the filing of a complaint, the court clerk shall issue a summons to be served as provided by yada yada yada. The summons must be issued in the name of the people of the state of Michigan, under the seal of the court that issued it. All right, so it's not going to be under a clerk seal, I don't believe. It's going to be in the name of the people of the state of Michigan. That's a subpoena. It's not these chintzy-ass summons they throw around at us that aren't completed right. No, this thing is going to be done absolutely correct and have all this information on it. The name and address of the court, names of the parties, the file number. Right, not just the court case number. The file number, whatever the hell that means. Local file number. Local file number. That would be on your birth documents. Name and address of the plaintiff. On and on and on. The name of the court clerk, the date on which the summons was issued, the date on which the summons is valid. All this has to be filled out properly and then properly served. So if you've ever been in a court case and the summons doesn't match what this says it does, well, guess what? Then your defendant was not personally notified. And you should be able to go to the court clerk and put in a motion based on this that you were not personally notified. I don't know exactly what the words will be yet. I'm just pointing out, here's something you could use that for. But you need to do the motion properly. Another thing you might do, this is out of the Constitution, the governor shall have the power to grant reprieves, communications, and pardons after convictions of all offenses, except cases of impeachment, upon conditions and limitations that he shall direct, subject to the procedure regulations prescribed by law. He shall inform legislature annually of each reprieve, yada yada yada. Right? So what could you do? Well, you could write the governor and say you were charged with a crime and they never put in a sworn complaint. And if he was to take judicial notice of the court case, the court record, that would be your evidence. Because there is no sworn complaint against you. They never put one in. Unless you've actually harmed somebody, and they probably have done it absolutely proper. But If it's a victimless crime, no. And just something real quick out of Blackstone. Blackstone says this was in a longer thing. The later of the Court of Common Pleas, which is a court of record and styled by Sir Edward Coke, the lock and key of the common law, and herein only can real actions, that is, actions which concern the right of freehold or realty, be originally brought, and all other or personal pleas between man and man are likewise here determined. Now, you're supposed to be in the Court of Common Pleas, which is one of the King's superior courts. But he goes on in another chapter to say the county court may also hold plea and many real actions and all personal actions to any amount by virtue of a special writ called a justices, which is a writ empowering the sheriff for the sake of dispatch to do the same justice in his county court as might otherwise had been done at Westminster. So what you want to ask is, there is a possibility what we're doing is we're going into a county court, which is more like a franchise court than one of the king's courts, under the control of the sheriff. Again, this isn't 10-star sheriff. This is an English sheriff. English sheriff is only elected 1 year at a time, for the most 3, and 1 year out of 3 or something like that, I think. But they got all sorts of ways they can do it. And the coroner is the only person. The coroner can take the office of the sheriff, but the sheriff cannot take the office of the coroner. And why do we like coroners? Well, because coroners, besides retrieving dead bodies, their main job was always to be the protector of the king's property and keeper of his pleas, of his orders, of his pleas of the crown. So, a lot being said here, right? So this really is about motions. Some other things of interest that would go with motions, the reasons we want to figure out how to do motions, and the fact that somehow you need to do an appearance, right? The way this is talking, this is really like a special appearance. Filing an appearance without taking any other action towards prosecution or defense of the action neither confers or enlarges the jurisdiction. It's just a way for you to get the other paperwork of the court case. So then you can decide what it is you need to do. And then you may want to ask for a motion, like an ex parte motion for contempt of court, because they're going to be suing in the name of a fictitious plaintiff. Or they haven't signed their complaint. And either well, you think about it this way: if nobody signed a sworn complaint, how can there be a complainant witness? The witness must be committing perjury. Got to be a complainant with a complaint sworn to. More on that in in upcoming video. So, all right, let's move on here. Moving on. Let's look at this name thing real quick. Alright, this is the my certified copy of record of birth. It's under a big old gold seal here that says Circuit Court of Bay County, Michigan. Well, Circuit Court of Bay County, I mean, really it shouldn't be there. It should just be a Circuit Court of Michigan, and this is one of the branches of it. This sounds to me like they're talking about a county court of Bay County. And this was something that Rose Circuit Court clerk told her, that to him, circuit means county. County Court of Bay County. There it is. Well, in the County Court of Bay County, this is the owner's certificate of title to a record, which is really a file, because 2137 is actually the file number, record number, right, of the birth record for me. And in this birth record, in this file, could be a infant's deed, a deed you were made a party to as an infant. It's never been read to you. It isn't necessarily bad, but you've never had it read to you. And in that deed, it could say, look, Ritluski, Robert Allen, you need to accept the surname Rytlewski before you can have your estate. And here's how you do it. And I haven't done it yet because they still have me in their records as Rytlewski, Robert Allen. Where did that happen at? It started right here on October 7th, 1958 when they made the record. September 5th, 1958, Rytlewski, Robert Allen. Then it was recorded 3 weeks later or so, or just over a month later, October 7th, 1958. Livre Book F, 2137. And then this was produced July 1963, about the age of 5. So my thought is, okay, I get a hold of the clerk there now and say, I would like to get a copy of my birth record. Now, people have tried to get their birth record before and they've been told, well, you need to have a court order. Well, as it turns out, the clerk can give you a court order. They did this. Right? They put the clerk's the one, Stephen Toth, county clerk down there bottom right, and their deputy clerk, they're the ones who put the court seal on it. They can give me a court order. I order the court to give me an order to get my birth record. Could do that. But I'm thinking, well, who do these people really work for? Right? They all work for the governor. And the governor is really like the ordinary of an ecclesiastic society known as the state of Michigan, because constitutions are ecclesiastic ordinances. Now, they may have Judeo-Christian beliefs, which I don't buy into myself, because you can't be a Jew and a Christian. Either you believe that Jesus Christ rose from the dead and is the King of Kings, Lord of Lords, or you believe you're waiting for the Messiah. In at least 3 of the Gospels, Jesus says that the law and the prophets ended with John the Baptist. We are now in the kingdom of heaven, and the lowest in the kingdom of heaven is higher than John the Baptist. Right? Do you want to be waiting for Christ to have risen, or do you want to say he did? You're already in the kingdom of heaven. What are you doing waiting for the second coming of Christ? He frickin' rose from the dead. That's the second coming. Let's take advantage of it. We're in the kingdom of heaven now. Sons of God, daughters of God, we need to go take our rightful place and conform the temporal order to the will of the Lord. And I think this is how they keep you from doing it. They got you down as Rytlewski, Robert Allen, right? So the mail's going to him. It ain't coming to Robert Allen Rytlewski. Not the good mail, not the official post office mail. It's going to Rytlewski, Robert Allen. Who, because this is in the county, and the county says if you're an inhabitant of the county, then your property is the county's property. I've shown that. I mean, that's what the law says. I've shown it numerous times in different videos. You're going to have to take my word for it here. That's what it says in Michigan. So I think we need to get this changed, right? That this is a problem. Rytlewski, Robert Allen, because of the surname and whatever the hell the thing was called. What do they call that thing? Name and arms clause. I haven't assumed the surname. If I had, then the record in the office of the recorder, which is really what this is, would have me down as Rytlewski, or Robert Allen Rytlewski. See, this says, I, Stephen Toth, clerk of the County of Bay and the circuit court thereof, the same being a court of record, having a seal, do hereby certify that the following is a copy of a record of birth of Robert Allen Rytlewski, all caps, now remaining in my office. The record is in his office. The whole thereof, it hasn't been split. He's got the full title in his office. The child, Robert Allen Rytlewski, all caps, is in his office. I want it. It's mine. That's the idea. We'll see. We'll see how that goes. So, close that. Hey, when I do that, close that one. Okay, that was the name. Let's look at the mail real quick. Alias street name. An alternate street name maintained at the 5-digit zip code level. So at the 5-digit zip code level, your street could have a different name. Maybe the name by which a street was formerly known. Formerly could mean properly known, or a commonly used nickname. They also have like a unique 4-digit number. This is the RFD. So the way they explain on the site, the rural free delivery system from the Postal Service allows the service not provided by city carriers, and keeps one's privacy by not telling others where you live. A unique 4-digit number is assigned to your residence, which must be written exactly in the following manner: 3100 RFD, or whatever number they give you. It is used for all mail and official purposes, or the post office will not guarantee delivery. It is not a post office box number. Its location, your street name, its location, your street name, is up to you to give out. You don't need to give them your street name. Please use our 4-digit number and street name for deliveries other than u.s.mail. The u.s.mail comes to the 4-digit without the street name. Then it goes on to say this is in the D041 Customer Mail Receptacles Manual. Every curbside mailbox must bear the following address information: a box number, if used, inscribed contrasting colors, yada yada yada, or a house number, if the street name and house numbers have been assigned by local authorities and the postmaster authorizes their use as a postal address. Right? Did the postmaster authorize you to use the house number and road name as your post office address? Might be good to know. Otherwise, you may not be getting the u.s.mail you want. But that's not all. Conditions of delivery. The D042 manual. Addressees may control delivery of the mail. Without contrary order, the mail is delivered as addressed. Mail addressed to several persons may be delivered to any one of them. Right? So without a contrary order, well, somebody could order them to send it to a different address. But how could they do that, Rob? Well, somehow you gave them power of attorney on one of these numerous unilateral contracts that you've signed, where only you've signed it. Unilateral contract of gift or donation, you just gifted away your property. You gave them power of attorney. They can go ahead and get a new address. If a person claiming to be the addressee of a certain mail is unknown to the delivery employee, the mail may be withheld pending identification of the claimant. So, it'd be good for us to maybe make sure they understand who we are. Now, I pointed out before that when I was at the post office one time, I had gone down there. I wanted to put in a criminal complaint, and they said, "Well, you send it to the to the postal inspectors." Okay. And somehow we got around to your address, and the postmaster said, "Well, we get your address from the county." And he thought about it for a second. He said, "I believe actually we get it from the zoning commission at the county." And I said, "Okay, that's cool." All right, and went on to do my thing because I was really into doing the complaint and hadn't really thought about it much since then until recently. But what he said is, "We get your address from the county." I should have asked him, "Well, what address do you have for me? Not my house. What do you have for Ritluski, Robert Allen, or Robert Allen Ritluski? What did they give you for an address?" And conflicting delivery orders. If persons make conflicting orders for delivery of the same mail and they cannot agree among themselves who should receive the mail may be delivered to a named receiver or a third party unanimously agreed to by disputing parties. If the disputing parties are unable to select a receiver, they must furnish the postmaster all available evidence on which they rely to exercise control over the disputed mail. The USPS may hold or return mail pending resolution of the dispute. Mail is delivered under a court order issued for mail claimed by different persons. So they could have a court order, because you're considered incompetent, or you were considered an infant, or you gave them power of attorney. Or they just said, hey, send it to us, and you haven't disputed it yet. Right? Because you're not getting mail for the court case. I just want to show this real quick. It has nothing to do with, this is really for another video, but I got it on here. We got to take it down. The Kane County Deputy Coroner shall support the Constitution of the United States, the Constitution of the State of Illinois, and shall faithfully discharge all legal mandate duties of the office of the coroner in accordance with Chapter 55 of the Illinois Compiled Law. That's a wonderful thing. The Kane County Deputy Coroner shall be a conservator of the peace. He's a guy you can take your complaint to. The Kane County Deputy Coroner. See, because the guy who's elected probably has some kind of defect, like he hasn't taken the proper oath or whatever, because these kind of positions, they don't let elected people take. It may look like they're getting them, but they're going to put the people they want into the positions of power, and they're going to stay there a long, long time. And the elected guys go in and out. They have a defect. They don't take the proper oath. They're not a registered elector within their district, whatever it is. They don't throw them out of office. They just don't let them do anything. They're a figurehead. The guy with the power is the deputies. And that's a perfect example. The Kane County Deputy Coroner shall be a conservator of the peace. Now, Roe did some checking. It doesn't look like it says that for the coroner, and it doesn't say for the chief deputy coroner. And, you know, you don't see this very often in somebody's job description where it says, and shall faithfully discharge all the legal and mandated duties of an office. You don't see that in somebody's job description. Yet, there it is. We're going to really be, Roe's going to be on this guy, seeing what he can do. Because conservators of the peace, subsequently they were appointed by the king. Right? Before Edward III, they were elected. After that, they were appointed. They're still appointed. The elected guys don't have no freaking power. They're figureheads. And what's the job of the conservator of the peace? To see that the king's peace was kept. And that's why you claim the king's peace when you go to a conservator of the peace. I claim the king's peace. What king? Well, the King of Kings, the Lord Jesus Christ, of course. I'm one of his sons. I claim his peace. In Virginia, who are conservators of the peace? Every judge and attorney of the Commonwealth. Every magistrate within the geographic area which he is appointed or elected shall be a conservator of the peace. In addition, every commissioner in chancery while sitting as a commissioner. But then it goes on to say that all these different federal things are conservators of the peace. United States Department of Justice, National Maritime Fisheries, Department of Treasury, so forth and so on. And I said, oh, this is why, way back when I got involved in this, I got involved because the first thing I was doing was trying to get rid of an IRS bill of, I don't know, $180,000 or something like that. They said I owed. And I had listened to a Gene Keating video or audio at one point. He was talking about the IRS manual 6209, which if you were to go today and Google 2013 IRS 6209, I'm sure you'll find a PDF, and you go to section 2, and it lists all of the documents of the IRS and what tax class goes with them. And all the things like W-2s, W-4s, all the 1099s, 1096s, I think, all sorts of stuff. They're all Class 5 gift and or estate. So if it's listed on a 1099 or W-2, it's not income. It's a gift or estate. Well, what's the exemption for gift or estate? I think about $5 million a year. Right, so what I did is I wrote and the reason I'm telling you this, because a buddy of mine, or a guy I've talked to before, everybody's a buddy, I guess one way or the other, he just spent 60 days in jail for an IRS issue. He got picked up at his house or whatever, right? You never know when they're going to show up. Boom. Went into court, didn't say what needed to be said, and spent some time in jail. If you got an IRS issue, what you want to do is you want to write the IRS and demand an audit. You want an audit for every year of the taxpayer because you may have made a mistake and you put down what should have been gift and estate by their own manual on a line on a form that says it was income. but it's not income. It's gift or estate, so I need to redo the forms. There's just too many of them. I want the IRS to give me an audit on all years of the taxpayer. That's what I did. They didn't respond, so I wrote them another one. They still didn't respond, so then I wrote the Treasury. And I got a call about a week later from a Treasury agent, wanted to stop and talk to me. Well, excellent. Let's have coffee. So we ended up doing that. So they are going to come talk to you. If you write the Treasury and say, hey, I've tried to get a hold of the IRS and won't give me an audit, all right, they're going to send somebody out to talk to you. And so it's like one of the first things I ever did as far as audio or anything. And I'm not going to go through the whole thing. But what I can tell you is, when they were trying to determine who I was, do you consider yourself a sovereign citizen? And I said, well, no, I'm a peaceful inhabitant. Well, as soon as I said the word peaceful, boom, you could tell, that put a little wrinkle in his eye, and we were on to a little bit different kind of conversation. And in the end, we shook hands. And I haven't been bothered. Ever since, I haven't been bothered by the IRS except one time since then. They showed up in my yard, one gal did. Want me to go up by her car, and she was talking about it, and I said, hey, I've already talked to the Treasury about this, that I want to have an audit. As soon as you guys give me an audit, I'm ready to come in and do it. Right? Until then, you're simulating a legal process, right? You're committing fraud. So, and she left. Haven't heard from them since. Right? And I probably owe them, according to them, over $250,000 now. I'm just saying, right? IRS Manual 6209. It's your best friend if you got an IRS issue, because it says in there all this stuff is gift and estate, and then they're going to say to you when you point this out, well, yeah, but that's an informational form, and you're going to say to them, so you agree with me that it's not income. If it's income, if you say it's income, you just need to swear to it. Put it on an affidavit under penalty of perjury. Otherwise, I demand an audit on all years of the taxpayer. Anywho, I got off subject a little bit, but that's good. Get all this stuff covered, all the things I want to talk about. It's good to free flow sometimes. Okay. So one of these things about the motion is really what this whole thing is called. Where did I put all these frickin' papers, man? Jeepers creepers. Defenses. I'm looking for demurrer. Unbelievable, Bob. Papers. Is it out here someplace? I had a thing in here. It was about demurrer. That's what it, as you can see, what it calls itself. My whole file. What did I do with the frickin' file? Now let's look at this real quick. Here's an entry of appearance form for someplace in Georgia. Entry of appearance comes now. Rytlewski, Robert Allen, and enters his or her appearance as the attorney of record for the defendant herein. This whatever day. I don't even need to tell him the defendant's name. Right? I don't have a Georgia non-applicable. I don't care. I'm going to say NA. It doesn't apply to me. I hereby certify that I have served a copy of this document upon the other party in the foregoing manner. Right? So you got to give a party to the other attorney of record. You are going to want to put your address in here and telephone number so they can get a hold of you. Right? But you don't have a law firm. So I guess I would call myself, so that I'm not breaking the law today, Rytlewski, Robert Allen, and enters his or her appearance as the attorney of record for the defendant. Because up here you're going to have the defendant, whatever they have your name as. And that way, any paperwork that is supposed to be going to the defendant, you're going to get because you're the attorney of record. They're supposed to send it to the attorney of record. If there's no attorney of record listed, then send it to the party. But the party, defendant, has a different address than you, so you're not going to get the mail. This is the only way you're going to get that mail. Fill this form out. Yeah, not ready for that one yet. Did all that one. Illinois mortgage security instrument. Cook County Chancery. Name. Mail. Alright. Hang on a second here.